Welcome to the final webinar in our series focusing on real disputes. My name is Stephanie Hepburn. I'm an associate in our property disputes team, and with me is my colleague Elaine Brailsford, who is a partner in our commercial litigation department.
Hello.
Today we're delivering part 2 of a two-part webinar on ransom strips in rural development. In part 1 we focused on what constitutes a ransom strip, how they come about and the issues that arise from them, and we also looked at the issue of encroachment. In today's webinar, Elaine is going to talk about evaluation of ransom strips, and then I'll touch on rectification and practical tips to avoid ransom strips. So I'll hand over to Elaine to start us off on valuation.
So I thought we should have a look at some cases in relation to the valuation of ransom strips, but also look at remedies and potential damages which can be claimed in an encroachment situation, which is not identical but very similar to a ransom situation. Those of you who may have dealt with ransom strips will be familiar with the view that the accepted basis for valuing the ransom strip is to attribute to it 1/3 of the increase in value of the adjacent land, and the case Stokes v Cambridge is trotted out as authority for that. Stokes v Cambridge was a decision of an English Lands Tribunal back in 1961. It did indeed hold in that case that the value should be 1/3 of the development gain, and the case set out a methodology for arriving at that. It determined the value of the subject land, deferred for 3 years for the sale of the proposed industrial development in plots. Then they deducted a developer's profit of 15%. Then they deducted a further sum for the cost of roads and infrastructure. And then they deducted the existing use value of the land, thus arriving at a figure which represented the increase in value, which could only be unlocked by the ransom access. They allocated 1/3 of that sum as the purchase price for the access. However, the critical part of the reasoning of the Lands Tribunal was the fact that the owner of the ransom strip, which was Cambridge Corporation, also owned other land which had the potential for industrial development, which potential might be released by the industrial development of the subject land. The Tribunal took into account the fact, as they put it, there was an inducement to the owner of the access strip to sell it as access in order to expedite his own interests. So it's against that background that the Tribunal came to the view that they thought 1/3 of the increased development value of the subject land was a fair price. The decision does not of itself provide support for the general proposition that the owner of a ransom strip will always be entitled to 1/3 of the increase in value of the adjacent land for enabling that increase to be achieved. It's also been said that Stokes v Cambridge is authority for a ceiling of 50% of the development value, and this seems to have been the take of the Scottish Lands Tribunal in the recent case Craigmile and others against the Keeper of the Registers of Scotland in 2016. We referred to this case in the first part of our webinar. It involved an area of land, a small triangular area, that had been incorrectly registered. The question was whether it was a ransom strip and what should be the quantum of damages the keeper required to pay Mr. Craigmile. It was accepted that the land had been incorrectly registered. It was argued for the keeper that the land was not in fact a ransom strip, as there were other alternative means of access. And these involved the realignment of a road, but there was in fact little evidence before the tribunal as to how that would definitively be achieved, although it was a possibility. It needed the cooperation of a third party. Thus the tribunal found the triangular area was a ransom strip. When it came to valuation, the parties were agreed on the approach that should be taken, and that was the method adopted in Stokes. The Craigmile's expert argued for 33% of the development gain, their counsel inviting the tribunal to adopt the conventional 1/3. And the keeper's expert argued for 25%, with her counsel submitting that it should be 1/4 on the basis that where there are 2 alternative options for access, the tribunal should award 25%, but if the tribunal held only one alternative, then the counsel for the keeper would agree with 33%. The tribunal went with 33%, but they also went on to say that apart from the methodology which is used, the critical element of Stokes was that it assigns a ceiling of 1/2 of the gain where the ransom strip constitutes the only key to unlocking the development. Mr. Craigmile's expert's evidence, in fact, had been that in practice there might be cases where the 50% figure could be exceeded. But when you look at the decision in Stokes, it does not in fact advance the proposition that there is in any event there's a ceiling of 1/2 of the gain. What the tribunal said in Stokes was that the exact proportion of the eventual profit that might have to be paid was a matter of conjecture. But in all the circumstances, and here they were referring to the circumstances of that case, they thought 1/2 was too much, so they substituted 1/3. Now, Stokes v Cambridge has also been referred to in non-ransom strip cases where there has been a very similar situation in that one party finds himself effectively held to ransom by the other. And these cases are very instructive in looking at the valuation of damages in these similar but not identical situations. The circumstances are usually where one party has encroached on the other's land and is at risk of being made to either stop a development or removing something that's already been built. In these situations, there's clearly the ability to hold one party to ransom. So to understand the ability to ransom an owner of land, we need to understand the remedies available in Scots law for encroachment. So the first remedy to look at is interdict. If you have a reasonable apprehension that your land is about to be encroached upon, the appropriate remedy is to interdict the threatened encroachment. Interim interdict will usually be granted as there will be a prima facie case that a wrongful act is about to be committed, and the balance of convenience will usually favour the status quo. In order to avoid that interdict, the encroacher may be prepared to pay a sum of damages. Situations very comparable to that of the ransom strip. In the English case Tamares Vincent Square Limited against Fairpoint Properties in 2007, the court set out the matters to be taken into account when assessing what sum would have been reached in negotiations between the parties had they made use of their respective bargaining positions. The case involved the infringement of a right of light, not something that exists in Scotland. But nonetheless, the principles are the same where you're seeking to stop something. The court considered and approved the decision in Stokes and set out the following principles. 1. The court had to attempt to find what would be a fair result of a hypothetical negotiation between the parties. 2. The context, including the nature and seriousness of the breach, had to be kept in mind. 3. The right to prevent a development gave the owner of the right a significant bargaining position. 4. The owner of the right with such a bargaining position would normally be expected to receive some part of the likely profit from the development. 5. If there was no evidence of the likely size of the profit, the court could do its best by awarding a suitable multiple of damages for loss of immunity. 6. If there was evidence of the likely size of the profit, the court should normally award a sum that took into account a fair percentage of the profit. 7. The size of the award should not in any event be so large that the development would not have taken place had such a sum been payable. And 8. After arriving at a figure which took into consideration all these above points and any other relevant factors, the court needed to consider whether the deal felt right. So these principles, with the exception of the seriousness of the breach, which clearly wouldn't apply in a ransom situation, a ransom strip situation as opposed to an encroachment, and the point about awarding a multiple of damages for loss of immunity, which is more of an English concept than a Scots law concept. But apart from these two, the other 6 principles I would say apply equally in a ransom strip situation as they do in an encroachment situation. Now, what of the situation where the wrongful act is not threatened but completed? The encroachment's already taken place, the building is already there on someone else's land. As a matter of Scots law, a party encroached upon is entitled to have the encroachment removed. I've been involved recently in two cases. I refer to both of these in part one of our webinar. And there are two cases where I sought removal of an encroachment. In one case, it was the removal of a retaining wall built by developers to increase the development area of their land. And the problem was the retaining wall stretched way back under the ground into our client's land. So there was no doubt it was an encroachment, and we sought removal, an immensely expensive task that would have been. The other case was a case where a cycle path was constructed over our client's land, and again we sought removal. In both cases, we were met with the response, well, the court's never going to order removal. Well, in fact, the court didn't, but that was because we reached an out-of-court settlement to avoid that possibility. The fact is, the principal remedy where there is encroachment is removal. Whilst the court has an equitable power to refuse that remedy, it will only exercise that power in very limited circumstances. So a recent case in 2015 demonstrates this. Monroe v. Finlayson was a decision of the Sheriff Principal of Grampian Highlands and Islands. Mr. Monroe sought declarator that he owned a small piece of ground which adjoined his property and that of his neighbours, and on which the neighbour had built a driveway. He sought removal and interdict. He was partially successful at first instance, the Sheriff granting an order for removal of only part, under exception of that part used for vehicular access. And Mr. Monroe appealed, and he was successful. The Sheriff Principal examined the extent of the discretion available to the court and looked at the long line of authority in that regard and concluded that the party seeking its application, in this case Mr. Finlayson, must have acted in good faith and the encroachment must be inconsiderable. In this case, the encroachment was not inconsiderable, and so the Sheriff Principal granted the appeal and thus the order for removal. In the course of the case, he said it was always open for the defenders to offer a compensatory payment, but they had not done so, and had thus imperilled their case on satisfying the court that the equitable considerations applied. So where does this all leave us? In the end of the day, whether it's a ransom strip or payment of a sum to avoid an order for removal, it's an exercise of looking at a hypothetical bargaining position and assessing the strengths of both parties. Stokes is not authority for the percentage of the development profit always to be 33%, nor is the case authority for saying that there is an absolute ceiling of 50% for all cases. Clearly, the owner of land that's being held to ransom, or the encroacher as the case may be, is not going to give up all the profit he might achieve. But there may well be circumstances which support more than 33% and indeed more than 50% being a fair result. Finally, I just want to mention where it may not be possible to ascertain any development profit. Such was the case in Horsford v. Bird, a case in England in 2006. It was in fact a case before the Privy Council. It involved the building of a swimming pool which encroached on the appellant's land. The court looked at what were proper considerations to be taken into account when assessing the quantum of damages. So they looked at the extent to which the encroached piece of land had enhanced the amenities of the respondent's house. And they looked at the cost of removing the incorrect wall and rebuilding it along the correct boundary line. They looked at how much the appellant could reasonably have sought from the respondent in November 2000 for the misappropriated land. Now, in my case involving the cycle path, we used the cost that the council could avoid by not having to take out the cycle path as an alternative damages claim to removal. Clearly, there wasn't a development profit as such in that case. And this approach is also one that was taken in Craigmile against the Keeper of Registers, which I've already referred to, in which that kind of payment was actually described as a frustration payment. You'll recall that the Keeper argued that there was in fact no ransom, but she offered as damages an amount equal to the cost the developers would have, equal to the amount the cost the developers would have to pay to avoid having to reroute their road, thus a frustration payment. And that was based on the cost and a margin on top. And that approach was approved of by the tribunal, although, as I've already said, they went down the ransom route case and awarded 33% of the development uplift. Now, Stephanie is going to talk about another remedy, which is that of rectification of the register.
Thanks, Elaine. Yeah, that's right. I wanted to touch upon when rectification of the land register may be a remedy in a potential ransom strip situation. As I said in the first webinar, the land register is a map-based system of land ownership. It's not a register of land occupation nor of intended ownership, and we'll come to see why that is important when I discuss a recent case that's come about in a moment. What the land register does then is give effect to changes of ownership agreed between parties, as evidenced by deeds that are given to the keeper for registration. That is not to say that the land register is never inaccurate. Errors do exist in the land register. Often these errors don't result in disputes, not least ransom strip disputes, but the possibility does remain that someone looking at their title on the face of it believes they have a ransom strip, when in reality the register is just incorrect, and in that case rectification may be an appropriate remedy, open to someone who has perhaps been held to ransom where the error is a result of an error in the register. So when is rectification possible then? Under Section 80 of the Land Registration etc. Scotland Act 2012, the keeper must rectify a manifest inaccuracy in the title sheet or the cadastral map, provided rectification is a manifest remedy. So it's like a double manifest test, essentially. In terms of Section 65 of the 2012 Acts, title sheet is inaccurate insofar as it misstates or wrongly depicts or shows what the position is in law or in fact. There's very little case law on what is manifest and what is an inaccuracy, and there's not any definition either in the legislation. In terms of Section 65, subsection 2, the cadastral map is not inaccurate insofar as it doesn't depict something that is correct only by reason of an exactness in the base map, i.e. the OS map, which is within the tolerances that are relevant to the scale of the map that's involved. And as we discussed in part 1 of the webinar, the published accuracy tolerance for rural maps is 1 metre. The inaccuracy must be clear and not reasonably disputable. What that really means is that the inaccuracy shouldn't really be in doubt. And an inaccuracy can be manifest if it's been determined judicially. Once the manifest error has been identified, the next stage then is to look at when the error occurred. If the error existed on or before 7 December 2014, the keeper will only rectify the land register if it would have been possible to rectify it under the previous legislation, the 1979 Act. And under the 1979 Act, the keeper wouldn't rectify the register against the proprietor in possession. There is a presumption that the proprietor is in possession unless the contrary can be shown. So what that really means is, if the error existed on or before 7th December, the person in possession of the land should win. In practice, though, what we find is the keeper often sits on the fence and won't rectify, and instead wants parties to try and reach an agreement before she'll rectify, and that often has the result of forcing parties into court. If you're making an application for rectification of an error that exists before 7 December 2014, the test for manifest inaccuracy and manifest remedy still applies, but the only difference to the present law is the proprietor in possession test applies. For 2012 Act titles, i.e. those where the error was there after 7th December 2014, possession doesn't matter, and the person who is entitled to the land, insofar as property law is concerned, wins. There's one caveat to this, and that is if there's an error in the land certificate or the title, and the land is sold with that error included, and the buyer was in good faith and has been in possession for a year, rectification isn't possible, and that's really just because the keeper wants there still to be some reliance on the land register. So it might be possible to have the register rectified in these circumstances that I've just set out, but what I wanted to look at is what happens with a keeper if she's faithfully followed the plans or documents that are given to her when the application for registration is made, and what they appear to show, and she's followed that. In that case, there's not an error in the land register. She's done what she was asked to do, even if it later turns out that what she was asked to do was not what the parties intended, and in that case, it's not possible to rectify the land register. One solution may be corrective conveyancing, I'll touch on that in a second, but there's a recent case that may help demonstrate the test in practice, and that's the case of John and Kirsten Higgs against the keeper and Mr. and Mrs. Harris. What this was an application under Section 82 of the 2012 Act, which allows a person with an interest to refer a question that relates to the accuracy of the register or what is required to rectify an inaccuracy in the register to the Lands Tribunal. And the facts of that case were, in 2000, Auchingill Farm in Kirkcudbright was divided into 4 parts. The farmhouse, the cottages and the farm were all sold, and that triggered first registration on the land register, with the remainder being retained. The farmhouse was bought by Mr. and Mrs. Higgs. A plan was given to the keeper to register the plan, but this plan was incorrect. The keeper looked at that plan and registered the boundaries of the farmhouse based on the plan. The cadastral map, as a result then, reflected what the plan said. The plan, however, wasn't correct. It was inconsistent with the description of the boundaries described in the deeds, and it didn't reflect what was on the ground. You're perhaps thinking, how did this error arise? How was the plan so wrong? Well, as I mentioned in webinar 1, the base plan for the cadastral map is the OS map. The Steading Road that led to Auchingill Farm wasn't on the OS map at the time. In fact, the road wasn't even built at the time. It wasn't to be built until after the split off of all these properties. Because the road wasn't yet on the OS map, what the surveyors did is draw the roads on the disposition plan and draw the boundary of the farmhouse to the east of that road, that manually drawn road. And that was clearly the intention of the parties. However, they drew the roads and consequently the boundary of the farmhouse in the wrong place. In short, for most of its length, the boundary of the farmhouse was on the wrong side, the west, as opposed to the east. And the result of that was that ownership of his access roads was excluded from the Higgs' ownership. As I said, the Higgs applied to the Lands Tribunal under Section 82, and what the Tribunal said was they looked at the plan that was given to the keeper, and the plan wasn't said to be taxative or demonstrative, so the keeper had to look at the verbal descriptions in the disposition. And what the Tribunal said was these verbal descriptions were hopelessly inadequate as a bounding description, not least because they reference roads and other boundary features that weren't actually even built at that time. The Tribunal regretfully concluded that neither the land register nor the cadastral map was inaccurate in its reflection of the boundaries. They said the fault wasn't the keepers, but it was really that of the surveyors and the solicitors who had failed by virtue of inadequate or insufficiently precise surveying and conveyancing to give effect to the client's agreements. The road was quite plainly drawn in the wrong place, and the boundaries were described in the disposition in terms that were so vague and uncertain the keeper was bound to be driven to rely on the plan. And the tribunal agreed that that was okay. The keeper could rely on the plan in reflecting the boundaries because of these terribly vague verbal descriptions. Not an ideal situation for the Higgs. They couldn't have their title rectified to reflect what the intention of the parties actually was. So where does that leave the Higgs then? Rectification wasn't possible. What other options might have been available to them? One option was corrective conveyancing, but that obviously relies on the cooperation of the owners on the land register, Mr. and Mrs. Harris, who, as we understand it, weren't very cooperative. If sort of conveyancing that's corrective isn't successful, one remedy might be under Section 8 of the Law Reform Miscellaneous Provision, the Scotland Act 1985, which provides for judicial rectification of defectively expressed documents, and that includes documents in the land register. It is subject to the proviso that where a property has been sold on to a third party who's acted in good faith, rectification can't take place. And that's one option that the Higgs may want to explore. Another option they could possibly explore is a professional negligence claim against the surveyors and or the solicitors. Let's look now then to conclude at avoiding ransom strips. No one wants to be in a ransom strip situation. Is there a way to avoid ransom strips from arising? The key message I think we want to give here is do not assume that your title or your client's title will never be challenged. One way of avoiding a ransom strip might be to use voluntary registration. More and more landowners are looking to this as an option for confirming their boundaries and providing certainty for the future. What voluntary registration does is confirms the extent of your ownership, and the mapping and title review process that's involved in that gives owners the chance to map their title and identify any issues in their title and resolve these before they become ransom strips. There are, we suspect, a number of savvy landowners out there who are registering land up and down the country in the hope that it might later become a ransom strip. However, it's important to bear in mind that voluntary registration is not a land grab. Landowners who are doing this, registering titles, must be satisfied they have good title to the area in question before they submit their application. They cannot mislead the keeper. You also have to be absolutely sure you don't leave any gaps when making the VR application, which could become ransom strips in the future. And accurate mapping is really key, and we saw that in the Higgs case. Although that wasn't a ransom strip situation, you can see where it may have become one if the owner on the land register wanted to develop that land, and the Higgs couldn't do so because somebody else owned it. One point that we see a bit of confusion around, and it's worth clarifying, is that a voluntary registration does not itself alter the ownership of land. What you're really doing is moving your title onto the land register. It's not a fix or opportunity to obtain titles that you don't already own, but it is a useful tool to provide an accurate and clear map of your boundaries and allow you, as I said, to become aware of any underlying issues that there might be. Second method that might avoid a ransom strip is having proper and good deed plans. There can be no registration under 2012 Act without mapping. Deed plans must now be submitted for registration unless an older plan is suitable, which show the land, any common areas. And it's important to get that right at the outset so that we don't end up in a Higgs situation where the plan on the land register does not reflect what's on the ground. Do not register the boundary feature. That's fundamental. We often see ransom strips arising because of issues identifying what the boundary feature is, especially in Elaine's case, as she's mentioned, where land is bounded by our roads, where you might see a number of boundary features running alongside the roads. We've had cases where there's been a stone dyke wall, often crumbling and not visible in places, a hedge, a post and wire fence that is designed to keep stock in a field, might be an older fence, a verge, and of course the edge of the tarmac extent of the roads. What's the legal boundary? That can often cause disputes. If you understand your ownership based on your staging title and what you have been possessing as including an area that is beyond a fenced boundary, we'd recommend that you ensure you register this as part of any voluntary registration application. Historically, the intention often was ownership was all the way to the edge of the road or the midline of the roads. But modern versions of the OS map have plotted, for example, the post and wire fence as the boundary. This gap between the post and wire fence and the edge or midline of the roads should be dealt with in an application for registration, otherwise a ransom strip situation could arise in the future. Approaching your neighbour may be a practical step to try and correct the issue, but bear in mind if you have title insurance, the insurers won't want you to speak to a neighbour and alert them to any issue. Speak to the local authority if there's a ransom strip being averred over land that bounds a public road. Consult the local authority, see if that road is adopted, perhaps look at affidavit evidence. If an issue arises, it may give rise to a ransom strip. It's prudent, we think, to get affidavits prepared, to speak to the extent of possession and the basis on which ownership is asserted. Always keep documentary evidence as to your title. Don't throw away old deeds, prior writs, historic plans, including lease plans. They could be relevant in the event of a later dispute. An old photograph or a plan may just be the final nail in the coffin in defeating a ransom strip claim. If an issue is identified, it's worth looking at obtaining title insurance so that in the event a claim is made, the insurers will either correct the position or provide cover in the event a loss is suffered, and insurers will often also cover legal costs. Even if you can't get title insurance, if a part of your land is challenged on the basis that it may be a ransom strip, it's worth taking your farm insurance policy to see if they will cover legal costs for defending any claim. I have a very quick but not exhaustive list of some methods you and your clients might want to consider if you're faced with a potential ransom strip situation. That really concludes our webinar series, and it concludes part 2 of the ransom strip webinar. We hope it's been helpful, and we are happy to take any questions offline. Our email is on the screen there, so please feel free to drop us an email or give us a call. Thank you very much.